So you're going to your favorite drive-thru to get yourself some breakfast or some lunch or something to snack on. And about the time that you've been sitting there 25 minutes, you realize that the whole reason the line hasn't moved is because some doucher of a cop is using his emergency lights to conduct a search and block the entire freaking drive-thru for 30 minutes. So you do what any normal American would do, and you tell him that he's a dickhead and he should move. Should you be arrested for that? Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. The exact scenario that I laid out in the beginning of this video is what happened to a Colorado man because he had the audacity to criticize police officers who were conducting a search. Now, in case you're not familiar with the facts, let me catch you up to speed. Josh Smith just wanted to get some food from a local restaurant called Humdinger's in Montrose, Colorado. He got there, found out that the drive-thru was being blocked by police officers that were dealing with a stolen vehicle. They were in the process of searching the stolen vehicle, and all Josh did was say, "Hey, dickhead, move your car," which is not a very nice thing to say to these hard-working police officers who are out there risking their lives while discovering people's sex toys and laughing about it and having a gay old time, if you will, just being good old taxpayer-funded police officers. One of the officers kind of chuckled at Josh's remark and told another officer, and that officer got a case of the red ass and decided to allow his ego to take center stage and went and addressed the issue with Josh. So without talking it to death, let's watch the body cam footage of what actually happened, and we'll come back and talk about it along the way.
Move your shit out the way, heads. There's nothing else though. He just looked. Interfering people from getting their cheeseburgers.
Is that this black car right here?
No, it was the silver car that's in the that went through the drive-thru.
Okay, so the first thing I want to draw your attention to is the timestamp on the video. So this happened back in October. We're looking at 17:20 when Mr. Smith makes his remarks to the police officers. And you'll notice that the thing that they do is they just go back to what they were doing because words, obviously, even hurled by a hangry person in a Humdinger's drive-thru, can't actually impede an officer's ability to do their job. But nonetheless, a minute later, after there's some discussion back and forth, one of these officers decides that they're going to take it upon themselves to go correct his behavior, because that's what the police are here to do, right? They're here to parent us, to guide us, to lead us by example, because they're so good at doing everything the right way. And so that's what this officer wanted to do with Mr. Smith. So he goes over and he has a conversation with Mr. Smith. Let's check out the timestamp when he has the conversation with Mr. Smith.
Quit yelling or you're going to get a citation, understood?
Yeah,
The lights are there. That means don't go by them, right?
Kind of way, I'm ordering my food.
Quiet. Order your food. Sam sex listing.
So are you wanting the standards in the combo or just by themselves?
Combo meal.
Are you wanting part
Colorado 564 X-ray Ocean.
Okay, so first of all, just for the sake of practicality, let's talk about something. What is the utility in telling a person to stop a thing that happened 2 minutes ago and hasn't happened since? In any world where any argument could be made, all the guy was trying to do was air his grievance that the police officers were being inconsiderate to business patrons. He might not have been polite about it, but that's what he was doing. So you have Mr. Smith saying what he said at 17:20. Some 90 seconds passes, and the officers are not affected in any way. And then Officer Hero here decides he's going to go over there and fix it. So he walks over, and some 2 minutes later, and of course Mr. Smith did what he should do, which is tell him to piss off. He's trying to order his food. You've already held me up for 30 minutes, dickhead. Why can't I order my food, right? I mean, that's what we're talking about. So the officer runs his plate, runs it through dispatch. The next body cam frame that we're going to cut to is some 12 minutes later, after he has waited for this guy to get his food. The guy said one sentence that the officer didn't like. The officer came over, tried to correct him. The guy said another sentence, told him to get out of his way so he could order his food. He gets his food and he goes on to move on with his life. And 12 minutes later, this police officer conducts an unlawful traffic stop and decides that he's going to give him a citation for disorderly conduct for the thing that he said 12 minutes ago that had no impact whatsoever on the officer's ability to do a job. Nobody was offended by this except Captain Insecurity over here, and he decided that he needed to be the person to change the world today.
And stopping now, right at the canal. You're gonna get a citation. I need your driver's license.
For what?
You can't
My
be flipping
citation?
people off. And
Oh, yeah, that's just like.
identify yourself.
No, I'm not.
Okay.
What am I getting?
Justin
for?
Scott, Jamie Scott, something like that.
Huh?
Any weapons in
There
there?
you go, bud.
Thank you. Hang tight, buddy. That's why you're getting a ticket. All right, Mr. Smith, there's your driver's license back. Can I get a phone number for you? I didn't hear you. So you get cited for disorderly conduct, obscene gesture. It's a $120 fine. You have a court date of November 28th, 2024 at Montrose Municipal Court. If you don't wish to pay the fine, you want to plead not guilty. If you do want to pay the fine, it's $120 fine. Pay it before that November 28th date, okay? Information on the back of the citation on how to do that. You just sign on the X saying you'll take care of it beforehand, or do it on that court day. I can't hear you, I'm sorry.
I'm not signing anything.
Okay. Refusing to sign? Can't be going around flipping people off, yelling at people.
You're a dumbass.
And that's why you're getting a citation.
Yeah. It's a citation. I'll beat it when I go to court.
Okay, that's what court's for.
Waste the fucking time.
Okay. Now, don't take your sad inhibitions on life out on somebody else, okay?
Shut the fuck up.
Have a wonderful day.
Shut the
Sergeant
fuck
English.
up.
That's why you're getting a ticket. Keep your mouth shut, please.
He issues this guy a citation for disorderly conduct, and in the disorderly conduct citation, his theory is to charge him under the obscenity part of the disorderly conduct statute in Colorado. So let's look at that real quick, and then we'll have some discussion about disorderly conduct and sort of the ways that it's changed, specifically in Colorado and under 10th Circuit jurisprudence. This is 18-9-106, disorderly conduct. You will note that he has been charged under subsection 1A, a person commits disorderly conduct if he or she intentionally, knowingly, or recklessly makes a coarse and obviously offensive utterance, gesture, or display in a public place, and the utterance, gesture, or display tends to incite an immediate breach of the peace. Now, this is a good time to talk about statutory language and how you can go about reading it to understand what the statute requires. There are two basic ideas. One is called conjunctive statutory language, and one is called disjunctive statutory language. You got conjunctive, that means they have to be connected. If something is conjunctive, it means that you've got one clause that is coupled to the second clause by the word and, meaning that both things have to be true in order for the element to be met. When you read the Colorado statute, it says, makes a coarse and obviously offensive, so it's got to be coarse and obviously offensive utterance, gesture, or display. It's got to be in a public place, and, okay, this is the conjunctive part, and the utterance, gesture, or display tends to incite an immediate breach of the peace, which is fighting words. In layperson's language, the thing I say to you has to be a thing that a normal person would find so offensive that it would cause them to smack me in the mouth or cause them to want to fight. That's what the Colorado statute requires. Regardless of the fact that Captain Insecurity here didn't read all the statute and he doesn't understand that if something is conjunctive, it has to have both parts in order for it to be a crime. It must tend to incite an immediate breach of the peace. That's what is required for you to be charged under Colorado law. Now, why is that? In order to understand that, we have to look back at a case from 1994 that was decided by the Supreme Court of Colorado called Aguilar. And what Aguilar was challenging was the fact that the statute in Colorado had been so broad that it was unconstitutional. In other words, it was sort of like the municipal ordinance in Houston versus Hill, and actually the court cited the Houston versus Hill in this case, where the court said, look, it's so broad that there's the potential that officer discretion will cause the police to enforce this in a way that it will infringe upon some protected speech. And because it could include protective speech, it's too broad. It needs to be limited in scope. That's what Houston versus Hill said. Well, Colorado did the same thing. They basically said, we're going to throw out Aguilar's convictions because how you've applied this statute to him illuminates the fact that this statute is too broad. We learned in Houston that there is a significant amount of criticism that can be levied at police and it be constitutionally protected speech. And for the same reasons that Houston said their ordinance was overbroad, the Colorado statute is also overbroad, and therefore it's suggested that the legislature change the statute to put a fighting words limitation in the language. And so it was a case from 1994 that said, no. You must be able to limit the scope of obscene gestures and displays in disorderly conduct statute in Colorado to make it to where the only thing that can be criminalized is fighting words or something that would cause an immediate breach of the peace. And that's why the statute now reads with an and. It must include this and in order to meet the elements. That is conjunctive statutory language. Disjunctive statutory language means it could be any of these things. So if you look back at the Colorado statute, you can see that it lays out different ways that this crime could be committed, right? So let's look at that real quick and we'll explore what disjunctive means. So A makes coarse and obvious offensive utterance, right? We went over that. So or makes it disjunctive. So it could be A, or it could be, well, B has been deleted, or it could be C, makes unreasonable noise in a public place or near a private residence that he has no right to occupy, or, and so you can see that there are multiple theories under which a person could be charged. So when they realized that the disorderly conduct wasn't going to stick, the prosecutor amended it to interfering with police, which is Colorado 18.8.104. Let's look at that. A person commits obstructing a peace officer, firefighter, emergency, blah, 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 when, by using or threatening to use violence, force, physical interference, or an obstacle, such person knowingly obstructs, impairs, or hinders the enforcement of the penal law or the preservation of the peace by a peace officer acting under the color of law, knowingly, blah, 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 blah. But here's an important part. They added 1.5, subsection 1.5. A person shall not be charged with the offense described in subsection 1 of this section because the person remained silent or because the person stated a verbal opposition to an order by a government official. So what's tricky here is that this violation actually came from the prosecutor. So the prosecutor made the decision to charge this person because of what they said in opposition to a police officer. So the prosecutor may actually lose qualified immunity in this case too, which is going to be an interesting scenario because I'm going to walk through a case now that will give you an example of where a prosecutor has found themselves on the losing end of a qualified immunity analysis because they instructed the police to arrest somebody based on a flawed understanding of probable cause. Obviously, the prosecutor should have just dismissed it, but what they've done is they've exposed themselves to liability because they, as a prosecuting authority, have made the decision to charge a person criminally by amending the charge for something that the statute specifically prohibits being charged for. So now we're going to pull up a case from the 10th Circuit from 2010 that is called Stearns v. Clarkson. And it actually, I'll give you the facts real quick. This is actually a Kansas case, but it's the 10th Circuit, so the same federal circuit as Colorado, and the disorderly conduct statute has virtually the same language in that it is limited to fighting words. So we have a guy whose father was killed by the police in this area. He goes to town for the funeral. Then he goes to the police officer's house who shot his dad, but the guy wasn't home. He knocks on the door, nobody answers, and he says, later. And the wife was actually behind the door, was listening, testified that she heard Mr. Stearns, this is the son of the dad who was killed by the police, who was there for the funeral, say later at the door of this police officer. So wife calls her husband, who's actually on duty at the time, and says, hey, this guy just showed up at our house. He knocked on the door. You weren't here. I heard him say later. I don't know what he meant. So this guy goes about looking for Mr. Stearns in his town. They finally have an encounter, and he pulls him over for nothing except for the fact that he heard that he was at his house earlier, right? So no traffic stop, no reason to pull him over other than to talk to him about what he did at his house earlier. So Mr. Stearns says, you're probably the MFer that shot my dad. So they have a standoff, whatever. They talk to a couple people. Somewhere along the way, he calls somebody calls the prosecutor, this guy named Smith, Christopher Smith. The prosecutor says, I think you have probable cause for disorderly conduct. You should go ahead and arrest that guy. So they end up doing exactly what the prosecutor told them to do. They end up arresting this guy. They book him into the jail. They strip search him. They do all kinds of stuff trying to find anything they can pin on him. He had no weapons. He had nothing. So no crimes committed whatsoever except for their interpretation of disorderly conduct. They also did it without obtaining a warrant. So they made a warrantless arrest for the one misdemeanor that didn't occur in the officer's presence by him knocking on the door, and then the second misdemeanor, they call a misdemeanor, that would have occurred in his presence, but it's based solely on him saying, you're probably the MFer that shot my dad. Okay, not a crime. So the court goes through and they basically said, no, officer, you made a warrantless arrest, for one, for something that wasn't a crime. There was no probable cause for it. Two, you made a warrantless arrest for something that wasn't a crime for him showing up at your house. And three, prosecutor told you to. All of you lose qualified immunity in that situation. And the 10th Circuit said, look, fighting words, it's very clear. Saying something like, you're probably the MFer that shot my dad is not fighting words. It doesn't constitute disorderly conduct, unlawful arrest, no qualified immunity. And not only no qualified immunity, but no qualified immunity for the prosecutor that told you that it was okay to do it. So if you want to read the opinion of this case and the whole facts, it's a pretty juicy story, actually. I'll leave the link in the description for you to read the whole opinion. But back to our case here, let's look at the update because all the charges were dismissed against our guy here from the drive-thru. Let's watch the news story.
A Montrose man fought the law, and today he won. This all stemmed from an incident last October where police had ticketed a man for swearing at them.
This morning, a judge dismissed the case after concluding what the man said was constitutionally protected freedom of speech. Kevin Vaughn from 9 News Investigates brought us this story last month. He joins us now. And Kevin, it sounds like this might not be the end, though, here.
Well, Kim and Tom, now that this criminal case has been dismissed, the man's attorney has promised to file a federal civil rights lawsuit. It was a stolen car case that could have been most memorable for the discovery of a sex toy.
I'm so sorry.
Could have been if Josh Smith hadn't shown up and voiced his displeasure that police cars made it tough to get into the drive-thru lane at Humdinger's.
When I said what I said, and then I thought it was over with.
It wasn't.
Quit yelling, you're going to get a citation, understood?
And after round two,
Nobody could get to the drive-thru for a half an hour.
that officer made good on his promise, ticketing Smith for making an obscene gesture.
I'm not signing anything.
That was later amended to interfering with police. Wednesday morning, the judge called Smith's behavior immature, offensive, and unnecessary, but also said it was free speech protected by the First Amendment. Bottom line, the interference charge was unconstitutional as applied in this case based on these facts.
I pretty much knew that we would win. I just didn't. I thought it would be like I thought it was going to actually have to go to trial.
That trial had been set for next week in Montrose Municipal Court. The question now is whether Smith will sue the city in federal court. The biggest question for the judge was ultimately whether Smith interfered with the work of those officers. In the ruling, the judge noted that the other officers were not prevented in searching that vehicle and doing the other things they were doing there. In the meantime, Smith's attorney has said he will sue Montrose for violating his constitutional right to free speech. We'll report on that if and when it happens. Live in the newsroom, Kevin Vaughn, 9 News.
It's pretty clear that the guy has like Parkinson's or something. He's having some involuntary movements. And he said, don't take your sad. And I don't know whether he says unambitious or what he said or miserable life out on somebody else. It's pretty ironic coming from this police officer that it was nothing but ego and hubris and his insecurities making their way to the forefront that caused him to go stop this guy in the first place. So, all that said, all charges dropped. Now he is filing a federal lawsuit, and I would almost guarantee that in the 10th Circuit, based on case law, this officer will lose qualified immunity for this arrest, because in order to survive qualified immunity, the police officer must be able to show that a reasonable police officer, even if mistaken, remember I'll talk about this arguable probable cause, the standard is that a reasonable police officer, even if he was mistaken, may have felt like, even mistakenly, that there was probable cause. There is no scenario where this works. You've got him yelling at 5:20 in the evening, them not addressing him until 2 minutes later when he's in the drive-thru ordering his food. They're interrupting him at this point. He hasn't done anything except say one thing that they didn't like and then went on about his day. All he did was just yell an insult or criticism at the police. They wait another 12 minutes. How do you articulate as a police officer that he was doing something at all that was causing a problem? He said one sentence and went on with his life. What need for enforcement action was there here? I mean, the whole idea of disorderly conduct is to say, if I don't do something about your behavior, it's going to cause a breach of the peace. What is your defense when you are the breach of the peace? When you are the person who's the aggressor in starting and escalating an encounter with this guy who just wanted to get his freaking lunch and go home? Like, it's bad enough that you wasted 30 minutes of his day, but you're going to stop him for no reason. Then they charge him for disorderly conduct. And I think that the prosecutor's going to have a problem for amending that charge in direct violation of Section 1.5 of that statute. So we'll see how it goes. I predict this will be an easy lawsuit. And if I was the prosecutor, I would count my blessings if he does not include me in the complaint to sue me because of the fact that I amended that charge in direct violation. We'll keep an eye on this and see what happens, but I suspect that this is going to be a qualified immunity stripping party out in Colorado. In closing, if you want to be taken seriously as a law enforcement officer, you must limit your enforcement action against at least people that you can make a reasonable argument that you were trying to stop them from doing something. How do you make an argument that they were interfering when nobody on the scene except you, who, by the way, obviously had no integral role in the search of the vehicle because you were able to stop what you were doing and leaving and go take up some fight with some guy that just wanted to get his food? So how do you make the argument first that there was disorderly conduct? What was he going to do that was charged in a breach of peace? He said one thing to you and then went on and ordered his food, went about his business. Everybody else thought it was funny. You're the one that had a problem. Then the prosecutor, instead of just dismissing it and being like, hey man, you shouldn't do that. No, they're stupid enough to put themselves in the middle of it and amend it to something that's actually illegal. How are people supposed to trust the police? How are people supposed to have faith in the criminal justice system? The one hope that you have as a citizen who's been unlawfully charged in the absence of probable cause is that when I get to the courtroom and explain this to lawyers, this thing's going to get dismissed, right? I mean, that's the one hope. And then you get a lawyer who acts like they're the union rep for the police department and that their entire function is to save the prosecution regardless of whether it was a bogus charge. So the prosecutor stupidly implicates themselves in their own unconstitutional application of the law and malicious prosecution just for the sake of backing up the police department. You don't have trust in the police because of the way they act, that's fine. But when you get to court, you're supposed to be able to get a fair and neutral outcome. Now, the judge thankfully did the right thing here, but this should have ended the second that the prosecutor's office found out about it. Any prosecutor with any sort of intestinal fortitude would have dismissed this case in a heartbeat and called this guy up and called his commander up and said, hey, you need to have a sit down with this guy. This was something that could get everybody in trouble. And it's not like Colorado has not had some law enforcement problems. Is this the kind of thing you really need to do? It's just completely lost on these guys that every single day you're losing more and more members of the public who trust and believe in the institution of law enforcement, and people like this are directly to blame for it. Anyway, that's all for this one, guys. I hope you got something out of it. I just wanted to bring it to your attention. I'll bring updates as they come out, and hopefully we'll get a big settlement for this guy and qualified immunity stripped by these police officers, and hopefully the prosecutor too. If you'd like to support the Southern Draw Law channel monetarily, I don't offer any type of memberships, but I'll leave my Venmo and PayPal link both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.